Testing, testing. Greetings, 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 greetings. It is I, your Lord, King Clifford Jefferson, Senator Godfrey the Fifth Count of Anjou, the son of Folk, the ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we here at the Third Temple English Church of England refer to as Jesus Christ, the Vicar of Christ, Melchizedek, or the King of Righteousness. It is November 29th, 2024, which is also equivalent to our Berber year, 2974. I greet you in the name of my Queen Sister Galveston from the House of Galveston. I greet you in the name of my Archbishop Belmont from the House of Belmont. I greet you in the name of all the heirs, predecessors, successors. I greet you in the name of the land that our forefathers had promised us. I greet you in the name of all that which is going to take place from this day forward. And with that, let's get started with this marvelous lesson. Greetings to Brother Kevin Newby from the House of Newby and Brother McGarrett from the House of McGarrett. Glad you were able to join me today in this beautiful lesson. Happy holidays for you all. Hope you all had your filling. But there's nothing is going to be more filling than the word of God. Okay? In the beginning was the word was God, word was God, and the word became flesh and dwelt amongst us all. Okay? So I have a beautiful lesson prepared for you all today. And the name of this lesson is called Deed. A change of name, which is called a deed pool. Sealed, signed, and delivered. A deed. A change of name, also called a deed pool. Sealed, signed, and delivered. This is going to be a good one for you all. I know that term deed pool is a very new term for you all. Greetings, Brother Newby. Nonetheless, it's going to be refreshing to be able to understand and comprehend as intended. Knowledge is power. Okay? Knowledge is power. Foolishness is a waste of time. Okay? I've searched the internet. I've been through all the platforms, and there's nothing out there politically, whether it's formal or informal, religiously, whether it's formal or informal. What else is there? Socially, whether it's formal or informal, there's nothing out here that's going to solve or resolve or remedify your problem that we are having here today as a nation of a people, okay? On a land that's made up of a nation of people. That is the equation that we must solve, okay? So all those at the sound of my voice, if you're able to pay attention, the direction will be clear, the path will be set, and the only thing left for you is to follow. Okay? So once again, I just want to give you an update on the matter pending before the court. The criminal matter is still scheduled for the 9th, which is 2 weeks from now, if I'm not mistaken. Which the public defender, I forgot her name, Yasmin Hafez, she already had my submitted motion brief for dismissal for lack of jurisdiction. The civil case that was pending based upon my affirmative defense filed this month. We had a motion scheduled hearing for a motion for dismissal and summary judgment on behalf of the defendants for stating in their claim that I failed to state a claim for which relief can be granted. I'm glad I did file it in the civil jurisdiction because it gave me the ability to be able to expose the hand that the state has in regards to the original complaint that was filed in the civil division, which was in an improper venue or improper jurisdiction in regards to bring the complaint, which nonetheless is still beneficial for us because when the motion for the dismissal and summary judgment was submitted before the court, I, in return, filed a motion for transfer to Chancery Court as a result of putting it in the proper jurisdiction, which is a motion that's pending to be heard the 6th of this month. But the judge ruling on the summary judgment and motion for dismissal was pending on the 22nd of this month, which he decided that following Monday, which he granted the motion for dismissal and summary judgment, which is warranted because I was in the proper jurisdiction, which means I was in the wrong venue. Nonetheless, though, I created a brief, all right, in regards to the proper venue in which it needs to be in to actually hear the matter in regards to being able to quiet the title on the clouded title that was created by the state in lieu of a title defect. Okay, so as a king, as a national, as a subject as well as a student, we learning every day, and I just give honor for the ability for me and my ability to be able to be studious, because as I grow, I learn. As I learn, I implement. Okay, so the next stage of this matter is having the matter referred or removed to Chancery Division, which supposed to be ruled on the 9th, on the 6th of this month, but the defendants filed a brief or opposition to that motion, being that the case was already dismissed based upon federal and state claim and the civil division, which they're right. But the matter now is going to be removed to the Chancery Division, which will be filed sometime this week. Okay, well, I will give you a look at the actual brief, and the brief now has a new party also involved in the matter, which is called the New Jersey Land Title Institute, which we're going to review and talk about today in this lecture in regards to the deed poll. Okay, very important that you pay attention because it's going to draw conclusions. It's going to solve a lot of the confusion as well as create a remedy in which we can be able to comprehend in regards to satisfactory genuine material fact that we're going to discuss today, which will be argued in the Chancery Court in regards to the stolen estate that belongs to you, i.e. my heir. So with that, let's get started with this marvelous lecture. Okay, greetings to Brother Newby again, Brother McGarrell. Once again, please pay attention to this marvelous lecture. If there's any comment, please leave them in the chat. If there's any donation, please send them to the Third Timothy English Church of England or $ Clifford Jefferson L. It's appreciated. As I said, this is a growing process for us. But like I said, our process, as I see, based upon my comprehension, is the best process because all the process that I've seen thus far that's been there prior to us is notwithstanding. Okay, so with that, let's get started with this marvelous lecture. I promise not to hold you long. I'm going to give honor to Archbishop Belmont from the House of Belmont for his studious and courage that he takes to continue to unfold as a archbishop as well as a student teacher here at the Third Timothy English Church of England by constantly reiterating our attentions on TikTok and all the other social platforms that's out there today. So great homage to you, Noble. All right, so let's get started. This is the new brief that will be filed this week in the Chancery Division, pretty much based upon the same argument that I brought in the Civil Division, which originally was brought to quiet the title on a cloud of title, i.e. a defect in the title. And that was based upon the statutory language of the statute, which governs property. That would be Title 46, Column 3-2, pursuant to New Jersey Administrative Rules on Civil and Criminal Justice 2A35-1, which clearly says that anybody has the interest in property in the hands of possession of another or a title to property that's in the possession of another have a right to have their matter heard before a Superior Court of New Jersey. That's 2A:35-1. 46:3-2 is the statute governing the arguments dealing with property. Title 46 is the title governing property. And then we have New Jersey Revised Statute 28:62-1, which is another statute that deals with New Jersey Administrative Justice, New Jersey Administrative Civil and Criminal Justice 28:62-1 that deals with quieting a title. Once again, quieting a title. When there's a cloud on the title, which means there's a defect in the title. As you can see, the plaintiff, King Clifford Jefferson, the Crown of England, which is my position, my title, which is a title of status, okay, that everyone has, all right, which we're going to talk about again, as well as the defendants, the state of New Jersey, as well as the Land Title Institute, which they were incorporated within the state of New Jersey pursuant to Title 45 and Title 17 of the revised statute, which we're loosely go over today, okay? No one's putting it down like your king. This is pretty much the letting the court know that to take notice of the complaint that's been filed in Chancery Division. All right. And I noticed that when I file a case in any court, they always like to change the name up, put my last name first, my first name last, and they never actually docket it like it's actually instituted in the actual complaint or docket. So this time it's going to be filed exactly how it is. I'm going to make sure of that, right? Just loosely going over the document, I'm going to go to the main source, actually the main part of the actual brief, which is the actual legal argument, okay? This is all your king's work. No help, no nothing. Civil division, real property, docket number, we won't get it until I get the TAN number or the TAN document to be able to serve the defendants, and then that will set the date for discovery, right? I'm not going to read all this. I'm not going to go through this for the sake of the time of the lesson. Then we got the certification, all right, by me. It's already made copies. It's already sealed. Got my signature and everything. So it's all ready to go, brothers and sisters. Then we got the actual brief. Whatever the honorable justice that will be hearing this matter, all right. The matter that they will be hearing is a chancery matter in regards to support a brief supported by a complaint to quiet a title. Okay, to quiet a title. This is what this whole lesson is about. Okay, to quiet the title. When I filed it in the civil complaint, it met the same standard. It was just I was in the wrong venue, which I'm glad I did that because it gave me the ability to be able to expose the defendant's hand. Okay, so now they can't raise the same argument in the civil complaint because the only argument they brought was an argument based upon dismissal for failure to state a claim, which relief can be granted. Okay, well, the proper jurisdiction where relief can be granted is the chancery court. So now you can't use that same argument in regards to lack of jurisdiction. Now you got to show that your interest, whether it's legal interest or equitable interest, in regards to the property in question, based upon the cloud that's been put upon you by you, the state of New Jersey, and New Jersey Land Title Insurance Company, which we're going to discuss today. All right. Once again, your king. All done by me. No assistance. No help. Everybody, if they like what they see, give me a thumbs up. Point one, plaintiff is entitled to all allodial land situated in New Jersey. Point two, defendants have converted the property belonging to the Crown of England into fee simple estate through common recovery practice. Okay? Point three, defendants have violated quid impetuous by converting fee intel estates into fee simple. All right, pursuant to New Jersey Revised Statute 46:3-5, a 2023 statute. All right, point 4. Defendants have violated the statute of entail by converting it into fee simple. New Jersey Revised Statute 46:3-15, a 2023 statute. Okay, this is the genuine material facts that's statutorily sound that no one can dispute. Okay, point 4. Point 5 points up. Defendants have used an abolished process of land conveyance called common recovery. Point 6. Defendants have admitted to converting allodial land of the Crown of England into fee simple estates. Okay, they have admitted it. Okay, I'm going to show you their admittance to the crime that they committed in regard to converting not just you, i.e., the natural people, all right, the nationals, i.e., the nobles. They converted you into chattel. That's the only way they can steal the land from you, by putting you in a status under a contractual agreement called an indenture contract, okay? By way of what we call a deed pool, by changing your name, the name that your mother and father gave you when you were born, without the need of any government influence. They changed your name when they registered it with the new government, i.e., the government that you are now a part of. No matter what document, no matter what instrument that they use to do it, it's still proof that a deed has been created, i.e., a deed pool. We're going to talk about this today, y'all. Greetings, brother Nooney from the House of Nooney. In conclusion, there's the president's constitutional citation, common law statutes, the exhibits, preliminary statement, all right, about what the public records says we are, okay? Well, they have an obligation because they were entrusted with that protection, okay? Title 47:1A-1 of New Jersey Revised Statute, okay? And then we get into what we call the statements of facts of the procedural history, okay? The statements of facts of the procedural history in regards to when we declare it a state of emergency, i.e. a state of necessity. Glad you were able to take time at work to join us, Brother Newman. All right? So the statements of facts of the procedural history, all right? This is our authority. While we have the right to standard of review, New Jersey Court Rule 4:62-1 dealing with quieted title, it states specifically that a complaint and an action in the Superior Court authorized by the statute to quiet and determine title and claims to property, real or personal, i.e., real or personal, real is the land, personal is the chattel, or any right or interest therein shall state the manner in which plaintiff either acquired title, i.e., in order for you to have the ownership, you must have the right first establish how you acquired the right of ownership in the title. And we know the word title means the right to possession. Okay? So it says that the complaint and the action in the Superior Court authorized by the statute 4:62-1, all right, authorized by statute to quiet and determine once and for all right, the title and claims to property, real or personal, or any right or interest therein, shall state the manner in which plaintiff either acquired the title or the right to possession, and to describe the property with such certainty that the defendants will be distinctively apprised of its location or character, and a judgment affecting the same may be entered according to that description. Under 46:62-2, the defendants must rebut the same each and every genuine material fact stated in the complaint in regards to 4:62-1 in regards to my reason for acquiring the title. Okay? And the legal arguments that I'm going to be raised is what we're going to go over today based upon the argument raised by New Jersey Land Title Insurance Institute, New Jersey Land, New Jersey Land Title Institute, because they were incorporated in the state of New Jersey and were authorized by the state of New Jersey to conduct business by way of them being licensed. Okay? Very, 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 very important. So what the complaint has established that's yet to be brought before the court, we're going to talk about it now in the King's Court, okay? On the King's bench with the King and his counsel, i.e., you are my counsel if you bring yourself up to comprehension, okay? So with that, let's get started with this marvelous lesson. New Jersey Land Title Institute. I'm going to show them how they stole your birthright, brothers and sisters. Never going to be seen anywhere else. New Jersey Land Title Institute, all right? New Jersey Land Title Institute is a license by the New Jersey Department of Banking and Insurance to offer the statutorily mandated course of study necessary to qualify for title insurance producer license examinations pursuant to New Jersey statute annotated 17:22A-1 at sequence. The institute is a not-for-profit New Jersey corporation. It is endorsed by New Jersey Land Title Association and its agency station. Okay, so the organization purposes is to sell title insurance, authorized and licensed by New Jersey Department of Banking and Insurance. Okay, New Jersey Department of Banking and Insurance. All right, everybody write that down because you're gonna need to know that. Yeah. I thought I brought that up. I know I got it here. Give me a second. No, let me put it in here. New Jersey Banking and Insurance. Okay. I thought I had it pulled up, but apparently I didn't. So let me pull it up now. New Jersey Bank Department of Banking and Insurance. New Jersey Department of Banking and Insurance is one of the 15 principal departments in New Jersey's government. The department mission is to regulate the banking, insurance, and real estate industry in a professional and timely manner that protects and educates consumers, i.e., you, and promotes the growth, financial stability, and efficiency of these industries. So, New Jersey Department of Banking and Insurance is responsible for what? The real estate brokers who sell you the property, all right, as well as insure the property, as well as give you the loan. Okay? So New Jersey has incorporated those three agencies: title insurance, banking, and realty. You must understand those three to comprehend this lesson. If you understand that, please give me a thumbs up in the chat line. So we know New Jersey Department of Banking and Insurance is has the authority over New Jersey Land Title Institute, which is the agency responsible for teaching those stakeholders how to uh, insure property that has defects in it. Okay, it's called it's called a defeasible title. They insure the they insure defeasible title because they can't insure an indefeasible title. Okay, once again, they insure defeasible title because they can't insure an indefeasible title. We'll talk about that in a second. Okay, so title insurance, which insures property owners in case there's a defect in the title. All right, that's their obligation. Okay, so no matter what else goes on in regard to the conveyance of property, i.e., how you acquired the property, how you came to possess the property, it's based upon the the system of fee simple. Okay, you got a third party mediating the process, licensed by the state of New Jersey, by the Department of Realty, who has authority to sell you the property, then has the ability to be able to have access to banking to get you a loan. And once you get that loan, establish that mortgage is a sign of indentureness, brothers and sisters. Okay? It's a sign of indentureness. We're going to talk about that today. All right? And then they cover themselves by getting you title insurance, okay? To insure you just in case somebody come back and say that that's their property. All right? We must understand that. All right? If you do, then we can continue on with this beautiful lesson. Let's just go to the New Jersey Revised statute that's authorized New Jersey Land Title Institute as well as New Jersey Department of Banking and Insurance. Okay, that's New Jersey Revised Statutes Title 17 1-1. Okay, a 2023 statute. I don't know what it is in your state, but in the state of New Jersey, where it concerns us, is under 17 1-1. Department of Banking and Insurance. All right. This is where you when you talk about your SES2K trust account, from a commercial understanding, this is what they're talking about. Okay. This is not we. This is not how. This is not how we understand it here at the Third Temple Church of England, because we understand trust law. All right. We understand trust law. All right. Not from a commercial aspect, but based upon an inheritance. All right. Descent, which is governed by operation of law. Okay. As you can see here, Department of Banking and Insurance, uh, Insurance Reconstituted, was created in regards to establishing what they call some type of escrow account or a trust account, which you call a SES2K. All right, which is basically one account that all the money, all the documents, all the interest, all the equity goes into. All right, that held separately under the guise of that third party, i.e., that mediator. Okay, that's licensed by the state. We must comprehend that. All right. New Jersey Department of Insurance hereafter in Title 17 of the revised statute, Title 17B of New Jersey statute, designated as a department created and established by the Act entitled an Act established a Department of Banking and Insurance. Approved February 10th, 1891, in charge with the execution, all right, of all laws related to insurance, banking, savings, trust, guarantees, safe deposits, indemnity insurance, i.e., title insurance, mortgages, debt pledge, investments, and loan corporations, continue and constituted as the principal department and the executive branch of the state government by the Department of Banking Insurance Act of 1948. Okay? So now this is the situation count that you're talking about that's set up whenever you go and purchase property. Okay? By way of some type of title, which we call a deed. I'm going to show you how they did it. All right. Property cannot own property. And then we have Title 45 of the revised statute. Colon 15-12.5. The Jersey by statute governs professionals and occupations, commerce, all right, trade. Very important. All this deals with indentureness, okay? Contractual agreement. Maintenance of special account required. This is your Set 2K or your trust account. All right. Every individual partnership or corporation licensed as a real estate broker shall maintain in a state or federally chartered bank, savings and loans association, or other depository institution physically located and authorized to transact business in the state and approved by the commission, i.e. freeholder, a special account into which the broker shall deposit and maintain all monies received while acting in the capacity of a real estate broker, i.e. a stakeholder, also called an escrow agent, or as a temporary custodian of funds of other and real estate transactions in the state. The account to be maintained in the name by which the individual partnership or corporation is licensed to do business as a broker and to be designated as either the broker trust account. You hear that? Trust account or escrow account, and should be maintained and separate and apart from all other personal business accounts. Okay? All checks, deposit slips produced as a result of the establishment of the account should contain the words trust account or escrow account. The provision of the subsection should not apply to an individual license as a broker salesperson. Okay, so they are the ones who act as beneficiaries for the acts as beneficiary for you, a beneficiary for the one who receives the benefit. Okay, that is you, the heir. Okay, we're talking about personal property or real property, whether you're receiving land or whether you're receiving intangible things. It's very important to understand how it fell subject to what we call bona vacationia, abandoned property, whether it's land, whether it's chattel, i.e., I'm talking about you, brothers and sisters. All right. If everybody comprehend that thus far, please give me a thumbs up in the chat. So we've got Title 17 and Title 45 in regards to the actors, okay, who keep a trust account or escrow account in regards to any account that's created based upon some type of interest in land, property, personal property, etc. Okay. Legal name. I think let's go ahead first. A legal name is a name that identifies a person for legal, administrative, and other official purposes. A person's legal birth name generally is the name of the person that was given for the purpose of registration of birth. The only reason why they register you with the government is for identification, so they can identify you. Okay, so they can identify you. That's the only purpose for them to register you with the government by way of what we call a birth registration. Okay, a birth registration, which then appears on a birth certificate, but may change subsequently. Most jurisdictions require the use of a legal name for all legal administrative purposes, and some jurisdictions permit a require a name change to be recorded at marriages. Whether you marry or not, name change is called a deed pool, which is a deed to change your name, which is not a contract because it only affects one individual. But as a result of that deed, it creates an indentured status, which becomes a contract as a result of it being registered under what they call servitude. Okay? Servitude. All right? So when they register you at birth with the government, you had that name prior to that. It was a noble name. It was a title of nobility. Okay? It was a surname and a given name going back to the founders of the name, which is the family. Okay? It becomes a family name, not a family name that are residents, but a family name that are nationals of that nation, which is the name of the nation that identifies the land called the country. Okay? I'm definitely on the spirit today. Okay? So your legal name was a name that your mother and father gave you. Okay? That's your legal name or your true name. Your legal name or your true name. When they put it on the birth certificate, that became a part of the vital record. And what was the purpose of this vital record? It was to create a legal document identifying that entity. Okay? It was created to create a legal document. The legal name may need to be used on various government issued documents, i.e., by either through a court order. The term is also used when an individual changes their name. You hear that? Change their name, typically after reaching a certain legal age. Very important again. A person may be able to change their name after you obtain a certain legal age. Okay? What is that looking at? All right, let's continue. Most jurisdictions require the use of a legal name for all legal administrative purposes. Did I miss something? Hold on. Yeah, for all legal administrative purposes, some jurisdictions permit or require a name change to be recorded at marriage. The legal name may need to be used on various government issued documents. All right. The term is also used when an individual changes their name, typically by reaching a certain legal age. All right. Usually 18 or over, though it can be as low as 14 in several European nations. A personal legal name typically is the same as their personal name, comprised of a given name and a surname. Okay, so this is very, very, very important to understand the intent of your name before it got registered with the government. Okay, before it got registered with the government, because when it got registered with the government, it became a part of what we call vital statistics. Okay, vital statistics, which is called civil registration. Civil registration. Birth registration or vital registration or civil registration are synonymous. I'm going through the terms. So no one will have an excuse. All right? Civil registration is a system by which a government records the vital events. They can't record you if they don't know your name. Okay? the vital events of its citizens and residents, i.e., once again, a civil registration is a system by which the government records the vital events of its citizens and residents. They have lied to you, brothers and sisters, because the only way to prove you are a resident is by having the form called the N400 form. No one, when they were born, signed this form called a N Form 400. It's required on a state level and a national level, i.e., the United States or the federal government, to determine if you are in fact a citizen by either being born or a citizen by being naturalized through the naturalization process, which is basically one and the same. There is no difference. The only difference is that if you're a naturalized citizen, you can't hold office for a president. Okay? Other than that, they are exactly the same. Civil registration is a system by which the government records vital events for its citizens and residents. Let's prove, in fact, that none of you are citizens, but you might be a resident, because resident means you reside somewhere. It don't mean you belong there. So let's prove that. Where is it at? I thought I had it. I'm going to read it from Wikipedia first. Then we're going to go to United States uh, immigration and see it as well. So if you claim to be a citizen, you better have this form. And if you got this form, that means you waived your right as a national if you filled this form out. If you didn't fill out this form, then you did not waive your right as a national. And that's subject to interpretation of what you identify as a national. Because you can be a national here in these lands, but being a foreign national contrast to being a national that's not foreign in this land and maintain your national status as a noble without renunciation through a oath of allegiance, which is a requirement for citizenship here in North America, whether you're naturalized or a resident. You must take an oath of allegiance, and that's required by filling out this form called the N400 form. Okay? So if you don't have this form, you're pretty much a foreigner. Okay? Form N400 is used to apply for United States citizenship through the naturalization process. Lawful permanent residents, also known as green card holders of the United States, who meet the eligibility requirements, can file N400 form to request citizenship. In the United States, 8.8 million lawful permanent residents are eligible to be naturalized. The only way you can become a citizen is to first become a resident for a certain amount of time. Okay? Becoming an American citizen gives the same rights and privileges of citizenship as natural born American citizens, except one, you cannot be a president if you are a naturalized citizen. Did everyone understand that? Please give me a thumbs up in the chat line. If you didn't, you better pay attention. The requirements for becoming a United States citizenship. Okay? First, you must be 18 years or above, be a lawful permanent resident in 5 years, have maintained continued residency during the past 5 years, have maintained physical presence during the past 5 years by way of being married to somebody who's a U.S. citizen. One, have a good moral character, have basic knowledge of English. I didn't say any other language, but English. Have basic knowledge of U.S. government and history. It ain't saying English history, but United States government history. All right, which is totally different. And the last and the ultimate test: take a oath of allegiance. You must take an oath of allegiance. Now, what's wrong with that picture? All right, especially for an English descendant. Let's see what's wrong with that. I'm not lying to you. U.S. Citizenship and Immigration Services. This is the requirement. If you have not met this requirement, you are not a citizen. Whether you were born here, whether you were naturalized, or whether you just decided to become a resident permanently or temporary. Okay? You must ask yourself this question right now. Because if you don't, you might be subject to deportation. Okay? This is no laughing joke. Chapter 2 of the United States Immigration Services regards to citizenship. Chapter 2, we already know the requirement or the last requirement for citizenship here based upon the N-400 form is a oath of allegiance. All right? But what does this oath of allegiance require? Okay? What is the detrimental aspect of taking this oath of allegiance to this country that you so-called register with by way of you being born and being registered by vital statistics, all right, by that legal document, okay? That legal document, not the one you receive when you leave the hospital, okay? All right, we're talking about that deed. The one you get is the contractual instrument that shows that a contract has been created and you're given the receipt that you're obligated to measure or meet the requirement of that contract because of the deed that was created for you by way of the deed poll. All right? Which is a result of your oath of allegiance, brothers and sisters. Okay? Your oath of allegiance is what got you in this trouble. All right? If you didn't give up your oath of allegiance, then that means that you are in fact a national. But of what country? Okay? Because if you are a national of a country, then the rights of that country that you claim to be a national of must protect you here. We have laws to protect us as nationals here in North America. All right? That's called the common law of England. Let's see. So the requirement as measured by the N-400 form is one, oath of allegiance. B, the authority to those who are able to administer oath. And C, renunciation of title or nobility. Okay? When you take an oath, okay, to become a citizen, whether naturalized or born, mean the same, or become a permanent or temporary resident, you take an oath of allegiance. When you take an oath of allegiance, one of the requirements for that oath of allegiance is the renunciation of the allegiance that you had prior to that oath of allegiance. It says it right here. Any applicant who has any titles of hereditary or positions of nobility in any foreign state must renounce the title or the position. The applicant must expressly renounce the title in a public ceremony. The United States citizenship immigrant, what is it? Services. All right, United States citizenship immigration services must record the renunciation as part of the proceedings. This is called a deed pool. Okay? They have changed your name from your national name, which is a title of nobility based off the surname, and created a trade name, which is a name that deals with employment under the auspices of what we call indenturedness. Okay? Failure to renounce the title or position shows a lack of attachment to the Constitution. i.e., their constitution. In order to renounce a title or position, the applicant must add one of the following phrases to the oath of allegiance. I further renounce the title of given title or title which I have heretofore held, or I further renounce the order of nobility given the order of nobility to which I have heretofore belonged. An application whose country or former nationality or origin abolished the title by law, or whom no longer possesses a title, is not required to drop that portion of his or her name that originally designated such title as part of his or her naturalization process. Okay? That's treason, y'all. They know you're committing treason. They don't give a damn. Why? Because this is how they stole your estate through the deed pool. All right? We understand that the civil registration or the voter registration was created to register you with this government by creating that legal document, all right, that identifies you, which is called a deed of a change of name, which now removes you based upon that status of that name, which is based upon the trade name, which is now in all capital letters, which remains what you call the trust, okay, which is in a state, okay, is your personal estate, not real estate, but a personal estate that's now is exceeded to the state as a result of interstate. Okay, and the only person who has the right to that is me. You don't believe me? Let's prove it. Deed pool from AI. Excuse me. Everybody like what they see so far? Give me a thumbs up in the chat. Reading C.A. Murphy from the House of Murphy. Reading Countess Walker from the House of Walker. The first use of a deed poll in England was in 1851. A deed poll is a legal document, all right? A legal document that can be used for a variety of purposes, okay? A variety of purposes. The purposes which we use the deed poll is based upon the origin of where it came from, and that's the law of England called the common law. How it being used today is it's being used to be able to usurp your estate and to what of that of a state of commerce, okay, through intentiousness. A deed poll is a legal document that can be used for the variety of purposes, including a changing a name, affirming a religious view, or renouncing titles or property. The term deed poll comes from the word deed or poll. So once again, when you renounce your status as a national, you renounce your title as a national by changing your name from a national to a national of the United States or the state by way of um, the process of being registered with that so-called administrative government. Okay? So now a deed has been created. All right? We must comprehend. Deed, a signed written undertaking that is not supported by consideration. The seal is considered to be the consideration that supports the obligation. So you don't have to be given consideration based upon the deed in lieu of some type of monetary conveyance or exchange or payment. The consideration is the seal on the deed poll. And that will be any sale that of any instrument or document that's given by the state. That is the consideration, brothers and sisters. Poll, and a archaic legal term for a document with straight edges. This distinguishes a deed that bound only one person from affecting more than one person. So a deed poll is not a contract. A deed poll is a deed because it affects one single person, and deed polls can be used for what? To change your name, or to record religious views, or to renounce title of nobility, or to renounce property. When you renounce, you know what renounce means. to give it up. All right. Let's move forward. So let's go to deed pool here. Since we got a general or formal definition of the word deed pool, we also get an ecclesiastical definition of the word deed pool because it said deed pool, all right, the origin of the etymology of the word deed pool is based upon a sale which warrants the conveyance and the authority by the conveyance based upon the sale, which is known as the consideration. A deed poll, plural, deeds poll, is a legal document binding one single person or several persons acting jointly to express an intention or create an obligation. It is a deed and not a contract because it binds only one party. So when I'm speaking about this, I'm talking to each and every one of you individually. Okay? All right? Let's look at the etymology of the word. The term deed, also known in this context as speciality, is a common to sign written undertakings not supported by consideration. The seal, even if it is not a literal wax seal, i.e., we know what a wax seal is, all right, but not only a notional one referred to by the execution formula, sign, seal, and deliver, okay? Going back to the store, all right? Going back to delivery in the delivery room, okay? Sign, seal, and deliver by way of a deed pool, which warrants the status of indentureness. This is what we're going to talk about because when you were born in a hospital, you were conveyed. You were delivered to the state, signed, sealed, and delivered by the cell, which put you in a state of indenturedness as an employee. I'm going to prove it to you. Okay? Pose is archaic legal term referring to a document with straight edges. This distinguishes a deed binding only one person from one affecting more than a single person, and a indenture so naming during the time when such agreement would be written out repeatedly on a single sheet. Then the copies separated by being irregularly torn or cut, indented, so that each party had a document with corresponding terms to discourage forgery. So that means that when they give you a carbon copy, that's the evidence of the original copy. So the carbon copy of the one that you were tore or the one that you received when you left was the contract of the indentureness that was created by the contractual agreement based upon the deed, which is called the deed pool, when they register a name with the government, which is a form of citizenship. Okay? Not true citizenship, but status denoting to citizenship because it created a legal document to identify you to protect your rights and protect your rights and protection that they now are going to bestow upon you as a citizen, whether you're naturalized, whether you are natural born, or whether you're a foreigner. Okay, no different. Greetings, Countess Middleton. So this brings up the term deed of a change of name because deeds of pools are used for the changing of names. It's also used for recording religious views or renouncing titles of nobility or renouncing property rights. Okay? Property rights. So a deed pool is also a changing a name, changing the status of your name, i.e., your titles of nobility. The most common use in the name through a deed of a change of name is referred to simply as a deed poll. You hear that? Deed poll. Very, very, very important. So if the instrument that you receive in regards to the deed poll, which is a deed, not a contract, because the deed affects the individual. When you receive the deed that was created based upon the registering with the civil records or the birth record called the birth registration, that now becomes an instrument that they use to enslave you at the status of indentureness. Okay? How many know what indenture means? Let's look at the word before we move forward. Indenture. An indenture is a legal contract that reflects an agreement between two parties. Although the term is most familiarly used to refer to a labor contract between an employer and a laborer with an indentured servant status. Historically, indentures were used for a variety of contracts, including transfers and rents of land, and even peace agreements between rulers. Did you understand that? So indenture is synonymous with indentured servants, which is synonymous with employment, which is synonymous with a trade name. Okay, a business name, a DBA. All right. We know it goes back to apprentices and all that stuff. We're not going to get into that. I just want to keep you focused on the intentions of this lesson. Okay, so it has to do with indenturedness. Very, very, very important that we understand this. Why? Let's see. Let's see. Damn, it's my part where I want to go with this. Right here. In the early history of the United States, many European immigrants served a period of indentured labor in order to pay the cost of their transportation. This practice was common during the 17th to 18th century, where over half of immigrants work off average of 3-year servitude. Okay, so when you talk about indenturedness in regard to those who were foreigners coming over to this land, they're not talking about us as the original English people. They're talking about foreigners who were allowed to come here and settle and took on the status as indentured servants. Okay, and it was recorded. They only switched places with you. How I know it? Let's prove it. A mortgage is called a deed of trust. A mortgage is called a deed of trust, where transfer of interest, all right, in, or whether it's legal interest or equitable interest, it transfers to somebody else, okay, by way of what we call a deed pool. Let's see what that is based upon the ecclesiastical definition of a deed pool. Because we understand the etymology of the word deed pool, the consideration of it is a sale. Okay? The consideration for it is what? A sale. Ecclesiastical deed pool is a valid form of a deed pool, and therefore deed in contract whereby a true person, a legal person, first expresses, affirms, and conveys certain rights to another party who are then lawfully bound upon proof of receipt in accordance with the canon defined under Article 133. That puts you in slavery. That's still because Article 133 defines sale. You don't believe me? Let's define it. 4.4 consensus instrument in regards to Article 133, Canon 23335. Seal is an act of affixing a symbol to a valid document to attest its valid production, recording, and registration, or to bind its contents as a solemn promise or execute its content by authority. So we have given them authority, or our parents have given them authority to take away our identity as legal persons, i.e., true persons, i.e., natural persons, by the express will of how we were registered. Okay? By a deed poll, which renounce, i.e., by an oath of allegiance to now become citizens of your state. But you never renounce it because there is no Form N-400 to show you to announce your citizenship. So you, in fact, are still noble. The problem is, what nobility did you come from? If everyone understand that and everyone like that, please give me a thumbs up in the chat line, okay? Because no matter how you look at, if you don't have our seal on it, that pretty much means that you are property. If you create an instrument and file it for the public record with your own seal, that has nothing to do with the status in regards to your right to be here on the land, okay? Because the whole thing is about property rights. Property rights, okay? Property rights can only be acquired. Either you were born with them or they were given to you. Okay? Whether you were born with them or they were given to you, these are called property rights. Okay? Let's get it, y'all. Oh, boy. Let's get it. Let's go on to the proof. This is one of the defendants, New Jersey Land Title Institute, which we know was incorporated by the state of New Jersey under Title 17 and Title 54. Okay? This is one of the exhibits that we're going to use as genuine material facts that cannot be disputed because they are aware of what they do, of what they've done. They have admitted it of what they did by using the word for our purpose and intent. For our purpose and intent. We know what that word means, right? For our purpose and intent. If we don't, let's just define the word. So when we read it, we know what it means based upon their meaning of the use. All right? This is what the word means based upon AI. They Belmont. They Belmont. That's what we call what we call what's the term? Nobiliary particle. Okay? De Beaumont is a nobiliary particle, which is associated with your title of nobility. This is why he constantly reiterate his descent. De Beaumont. Mine is son of. A parliamentary, nobiliary particle is either de or of. My name is Godfrey Jefferson, or Godfrey's son. Son is the prefix means son of Godfrey. Just like de Belmont, he descended down from the Belmonts. De, okay? We're going to discuss that in 1 second. Just give me a second. For the purpose, for our purpose means, okay? In relation to what we are trying to achieve, or as far as our goals are concerned, essentially indicating that something is relevant or sufficient only within the specific context of the current situation or discussion. So when you make or use the term for our purpose, it means in relation to what you are trying to achieve, or as far as the goals are concerned, essentially indicating that something is relevant or sufficiently only within the specific context of the current situation, all right, of the, where is that, of the current situation or discussion, all right? We must understand that because they're going to use this word for our purpose several times, okay? Several times. History and Development of Land Ownership and Conveyance. This is from New Jersey Land Title Institute that was incorporated in the state of New Jersey under Title 17. All right. And we know that Land Title Insurance Institute, in order for you to get title insurance, you must have the license to insure. Okay. And when they insure defects on the title, i.e., clouds on the title. And this is the reason why we filed our claim to acquire the title because it's defective. Okay? Because it's defective. Everybody bear with me for a second. Once again, this New Jersey Land Title Institute. Sorry for keeping my brothers and my sisters, my family. History of Development of Land Ownership Conveyances as told by New Jersey Land Title Institute which was incorporated in the state of New Jersey. That means that not only New Jersey understands the history of development of land ownership and conveyancing, but the corporation which was incorporated in the state of New Jersey to ensure conveyance of property as a result of them having effective titles are aware of the history in regards to the conveyance of land ownership and how they acquired the land ownership and the ability to be able to subjugate it, i.e., convey it to somebody else. Let's discuss this. Let's talk about this and just see how it's being done under the modern form of land conveyance, which is totally contradictory to how it's supposed to be. All right. So let's see the convincing evidence, the genuine material facts that's told by the defendants in this article in New Jersey Land Title Institute. All right. And the fraud that has been committed. Let's read it for ourselves. First of all, let's look at what the word title insurance means. Title insurance. Since we're reading an article from a title insurance company, let's understand what title insurance is to see if they really know what the hell they're talking about. Because I don't think they do. Title insurance is a form of indemnity insurance. It's predominantly found in the United States and Canada that insures against financial losses from defects and titles to real property and from the invalidity or enforceability of mortgage loans. Unlike some land registration systems in countries outside the United States recorders of deeds generally do not guarantee indefeasible titles to those who recorded titles. They only insure defeasible titles, meaning that they only insure defects in titles. We must understand this because this is the whole key about understanding how they took your estate from you. Okay? All right? Title insurance only insures defects in titles. When there's a defect in a title, that means there are cloud in the title. Okay? Title insurance would defend against the loss who attacking the title and reimburse the insured for the actual monetary losses incurred up to the dollar amount of the insurance provided by the policy. This is called compensation. Okay? Consideration. Okay? The first title company of Law Property Insurance and Trust Society was formed in what? Pennsylvania, the same area where they used the first lobbying season conveyance ceremonial conveyance that was brought forth or created by our ancestors. All right, going back to Ashton. All right, it says typically the real property interests insured are fee simple ownership or mortgages. You hear that? Fee simple mortgages, fee simple ownership or mortgages, which is one and the same. However, these type of insurances can be purchased to insure any interest in real property, including easement, leases, or life estates, which is all forms of possessions. Okay? You're right. All state titles are indefeasible because the title is nothing more than an instrument showing possession. It doesn't show ownership. Okay? We know it has to do with ownership because it's in your possession, but it doesn't necessarily prove that you actually own it. Why? Because there's title insurance, and if there's title insurance, there's a defect in the title. And when there's a defect in the title, that means there's a cloud in the title. And the only way that cloud can be cleared, sunny day, blue skies, is to quiet the title. Okay? It's to quiet the title. So what is the cloud on the title? Let's look at that definition first. So title insurance shows defects in the title, and defects in the title is called clouds in the title. Okay? In the United States, property law, a cloud on title or title defect is an irregularity in a chain of title of property, usually real property, that would give a reasonable person pause before accepting a conveyance of a title. According to Investopedia, a cloud can be defined as any document, claim, unreleased lien, or encumbrance that might invalidate or impair the title to real property or make the title doubtful. Clouds on titles are usually discovered during a title search of the public record or the county record. Cloud titles thus be contrasted with a clear title, which indicates that the property is unencumbered, meaning that it's either entail or allodial. Okay? We must comprehend that. All right? So if there's a cloud on the title, that means there's a defect in the title. And if there's a defect in the title, then you must have title insurance. And if you got title insurance on any property by way of a mortgage, then guess what, brothers and sisters? 99.99%, you do not own it. If anything, you owe because the title is not clear. Now you know you owe. The question is becomes who do you owe? Because the person who's owed just do is the owner. Okay? It is the owner. And only the owner can quiet the title. So what does it mean to quiet a title? Let's look at it. You're never going to hear it this simple, my brothers and sisters. You're never going to hear it this simple. Everyone like to hear it thus far? Give me a thumbs up in the chat line. If you like what you're hearing thus far, give me a thumbs up in the chat line. If you comprehend this thus far, give me a thumbs up in the chat line. If you don't comprehend it, please state I don't know. Because if you say you know, I'm going to hold you accountable. So if you don't know, please say you don't know. And if you like what you're hearing, give me a thumbs up. All right? It's okay to say I don't know because it gives you ability to grow. All right? Thank you for all being honest. Because at one time I didn't know. An action to quiet a title is a lawsuit brought in a court having jurisdiction over property disputes in order to establish a party's title to real property or personal property having a title against anyone and everyone and thus quiet and challenges or claims to the title. Did everyone understand that? This legal action is brought to remove any clouds on the title so that the plaintiff and thus in privity with them may forever be free of claims against the said property, whether it's real property or personal property. The action to acquire title resembles other forms of preventive adjudication, such as declaratory adjustment, such as what we call an ejectment, trespass, waste. These are all common law torts by way of necessity, which is justified under the criminal law, New Jersey Revised Statute Title 2C 3-3 and 3-2. Okay? Grounds for a quiet title action on a complaint. It comprises a complaint that the ownership of title of a parcel of land or other real property is defective in some fashion, typically where title to the property is ambiguous. For example, where it has been conveyed by a quitclaim deed, which majority of you have, through which the previous owner declaims all interest in it by putting a lien on it called a lis pendens, but does not promise that a good title is conveyed. Such an action may also be brought to dispel a restraint on alienation or another party's claim of non-possessory interest in land, such as an easement, eminent domain, compulsory purchase, prescription of sovereignty, and such as those caused by even a prescription, which is a non-possessory interest in property that you do not own. Okay, so the main reason why a quiet title had been brought forth on behalf of a property that has been clouded by a title which is defective by way of the defendants is because they don't actually own it. Okay? They don't actually own it. All right? So a quiet title is to remove the clouded title or to remove the defect in the title by once and for all proving who owns it. Why? Because if you look, the first one it says is allodial. Allodial means free and clear, unencumbered. Okay? New Jersey don't own the state of Lodi. United States don't own the land of Lodi because they have encumbrances. All right, taxes. Thus, there is no true allodial. Okay, we must comprehend this goal I'm giving you. So, what is restraints on alienation? How many of you know what that means? Restraints on alienation, which is the justification of the necessity of why I'm doing what I'm doing in these courtrooms today. To restrain them from alienating not just you from the land by way of the dead poll and by employing you by way of the indentured servitude, which we're going to discuss in a second, but also by returning the land back to the original owner by removing the cloud on the title, which is a defect in the title based upon the title insurance that the defendants have put on it. All right? We must comprehend. What is a restraint on alienation? A restraint on alienation is the law of property, is a clause used in the conveyance of real property that seeks to prohibit the recipient, i.e., the transferee, all right, not the transferor, but the transferee, the grantee, from selling or otherwise transferring their interest in the property. When you do that, this is called alienation, which is called subfeudation, which is a violation of Queen Imperatrice, a law passed by our ancestors of the Plantagenet crown. Edward the First, son of Henry the Third, the son of John, the son of Henry the Second, the son of Godfrey, the son of Folk, the ruler of Jerusalem, which we now call the Garden State. Okay? So a restraint on alienation is a law of property rights, which is a clause used in the conveyance or the transfer of real property that seeks to stop a recipient, i.e., somebody who doesn't supposed to have the right in the possession, such as defendants, from selling or otherwise transfer their interest in the property in which is the conditions being subject to today. Under the common law, such restraints are void against the public policy of allowing landowners to freely dispose of their property. Perhaps the ultimate restraint on alienation was what? Fee-tail. Fee-tail, a form of ownership which required that property be passed down in the same family from generation to generation, which has also been widely abolished. I didn't write that. They wrote this. Why? Because they understand Queen Imperatrice. They understand free and common socis as defined in the New Jersey Revised Statute, which we've been through so many lessons. We talked about these statutes that are presently in the statute in 2023, but we don't understand the language. So let's understand the language before we go into the evidence of the genuine material facts that's now been even disputed by the defendants who are yet to be brought before the court of law in chancery, i.e., the king's bench, because the chancellor is responsible for the king's conscience. So I'm pretty sure when they get this complaint, they're going to know what the hell I'm talking about. Okay? How many can talk fluent like that? How many of us can talk fluent like this? Let's see. Queen Imperatrice. Well said, Countess Walker. Don't forget the word Deadpool indentured. Don't forget it means the renunciation of titles of nobility by becoming a citizen by oath of allegiance to that form N400. If you haven't filled that form out, that means you still got a chance. You still have a chance. I don't care what nation you come from. All right? You have two choices to make. You're either going to choose the nation where you come from or the nation you're subject to now. Queen Imperatrice, passed in 1290, is a statute passed by the Parliament of England, not Ireland, not Scotland, but England in 1290 during the reign of Edward I that prevented tenants in chief, okay, from alienating their land to others by subfeudation. If a tenant died or a tenant in chief died, that means it was subject to what we call inquisition post mortem, which is subject to library of season, which means that it is ceded to the crown because the crown is the highest excheater, okay, because he's considered Lord Paramount, because Lord Paramount receives common soakage. Why? Because the land is allodial. Why? Because there is no heirs. All right? They are assumed to be dead and gone. Queen of Pretorius. Queen of Pretorius, a statute passed by a Parliament of England in 1290 during the reign of Edward I that prevented tenants, i.e., tenants in chief, from alienating the lands to others by what we call subinfeudation. Instead, requiring all tenants who wish to alienate their land to do so by substitution, which means to substitute somebody in place of you under the same fief that was given by the grantor, i.e., the transfer, which usually was either the landlord or the lord paramount, i.e., that's the crown or the monarch. The statute, along with the companion for a warrantor, which is the order to show cause, was passed in 1290, was intended to remedy land ownership disputes and consequent financial difficulties that had resulted from decline of the traditional feudal system. In England, during the High Middle Ages, Queen Pretorius was called a statute of our Lord the King concerning the buying and the selling of land. Once again, the statute of our Lord Majesty the King in regards to buying and the selling of land. That is what the statute's intent was for. Okay? Let's get into it. Background. Prior to the Norman conquest of England in 1066, the Anglo-Saxon law of land succession was customary. Land or folk land or book land, as it was called, was held a allodial title by the group, meaning the group held the land. There is no true allodial land now by the group because the group is considered to be intestate, meaning dead. So the only power of the allodial is Lord Paramount, which represents the crown, because he's the highest esteeter when the land is left vacant, i.e. bona vacantinia, i.e. abandoned. We must comprehend these terms, okay? So prior to us living on the land where there is no feudal laws, it was considered regular land tenure called folk land or book land. Very, very important you comprehend that. All right. So we know that the origin of Queen Pretorius was created to stop subinfeudation, which is the alienation of land, all right, which was passed by Edward I, all right? It was passed by Edward I, all right? Now, we know what Queen Pretorius is, and we know what subinfeudation means to not alienate it, but let's just look it up just for the sake of understanding the true definition of the word. Subinfeudation, which was the purpose of Queen Pretorius. I believe in letting you see it for yourself. Greetings, brother Cornier from the House of Cornier. Glad you were able to join us. In English law, subinfeudation, i.e. alienation, or the authority to alienate land, and the only way you can do that is by acquiring the possession of the land to be able to convey it, all right? Now, the problem becomes how you came to acquire the land in lieu of your possession, i.e., ownership, all right, to convey such land through the process of subinfeudation, i.e., alienating the land through either voluntary alienation or what we call voluntary or involuntary alienation. Okay, only two ways. In English law, subinfeudation is the practice by which tenants in chief holding land under the king or other superior lord, i.e., the landlord, carved out new distinct tenures, i.e., land tenures, i.e., parcel estates or partial estates or just estates on land, and then in their turn by subletting or subleasing or alienating that part of that land to somebody else who does not supposed to be having it. The tenant was termed the menagerie law with regard to those holding from them to immediate tenants being tenants in capitite. The lowest tenant was called the freeholder, now called commissioner, or as he was sometimes called, tenant in prevail. The crown, who is in theory owned all land, was called what? Lord Paramount. You hear that? The crown, i.e., the king, was called Lord Paramount, and only Lord Paramount receives common soakage. All right, only the Lord Paramount receives common soakage, and that's only a result of serfs and villains and peasants that were allowed to be on the land. These are not heirs we're talking about. So it said the great lords looked with dissatisfaction on the increase of subtenures. Accordingly, in 1290, a statute was passed by Queen Praetorius, which allowed the tenants to alienate it whenever he pleased, but the person to whom he granted the land was to hold it in the same to the same immediate lord as by the same services as the alienor held it before. All right, the one who alienated it. All right. So that's the process of subfeudation, which we know the only way you can get that power is by way of being a tenant in chief or a landlord or what they call tenant in chief. All right. And the only way you can receive that authority is by the authority granted to you by the king. Okay. Which is considered what we call Lord Paramount. Okay. So what is the word Lord Paramount? Lord Paramount. A Lord Paramount is a term of art in feudal lore describing an overlord who holds his own fief from no superior landlord, and thus describes a person who holds a lordlio title, owing no soccage or feudal obligation such as a military service. This was distinct from the manage lord who hold his own fief from the superior. Okay, so we know that the Lord Paramount versus the tenant in chief were two statuses of how a person came to acquire possession of an estate and land. Okay, but the highest form of ownership free of an Indian encumbrance was the Lord Paramount, which held the land in Lolio, which will only fit the description of the crown or the king. All right, because that's what was described under what we call soakage. So let's define the word soakage, because we know the king owes no soakage because soakage is due to the king. All right. If everybody like how I'm breaking this down to you today, please give me a thumbs up in the chat line. Soakage. Soakage was a feudal duty and land tenure forms in English feudal system. It eventually evolved into freehold tenures called free and common soakage, which did not involve feudal duties. Farmers held land in exchange for clearly defined fixed payments made out specified intervals to feudal lords. In turn, the lord was obligated to provide certain services such as protection to farmers and other duties to the crown. Payment usually took the form of cash, but occasionally could be made with goods. This is what you call rent, brothers and sisters. This is what you call rent. I hope y'all ain't falling asleep on me. I only see one thumbs up, and that's from two, or now that's three. One gave me a fire. I like that. All right. So soakage was a fee paid to the king, who was Lord Paramount. Okay, because there was no encumbrances imposed upon him because he was the highest. Okay. Soakage contrasts with other forms of tenure, including Surgeon Chief, Franklin Moore, and night services. Key point you need to focus on right now. An English statutes in regards to common soakage that was created under Queen Imperatrice, passed in 1290 by Edward I, establishes y'all. You hear me? Establishes that soakage tenures, which passes from one generation, all right, to the next, until that nominee or primogenitor or heir came to reign through what we call taking the position of the crown. Because we know until that person come in age, all land remains in this treatment, which resorts to the crown. Hold that thought. Sorry about that. All right. So we're talking about sokas. Soka is only reserved for the crown, as you can see, and we know the crown represents the king. The king represents the monarch. We know the monarch is the corporation soul, which represents a natural person. Key point about Queen Pretoria that was passed by Edward I, which we will see in the New Jersey Revised Statute, which we'll talk about in a second, which we're reiterating now based upon what Wikipedia has to say about it. That says that this statute that was passed by Edward I back in 1290 was uh, was a continuous statute that was promulgated and instituted for that nominee. Because it said the English statute Queen Pretoria Edward I established that socis tenures, which passed from one generation or nominee to the next, will be subject to inquisition post-mortem, which would usually involve feudal relief tax called common socis. This contrasts with the treatment of leases, which could be lifelong or readily subject to forfeiture and rent increases. So we understand common socis was reserved for the Lord Paramount, i.e. the king, i.e. the crown, i.e. the monarch, uh, who holds the position to be able to convey land, okay? And when that monarch comes to his demise, then the next one has to come and fit the position, which is regards to coming of age, all right? This involves what we call inquisition post-mortem, all right? Inquisition post-mortem. But when we define inquisition post-mortem, we're going to look at it through what we call the eyes of how delivery of possession of land is actually conveyed, called library of season, which is the process that I use when I filed it in the county in regards to returning the low legal land back to not just the king, but the heirs through what we call library of law process, which means we go into the side of the property and declare that it now belongs to us. All right, which we see through the Inquisition postmortem process, which was preserved throughout generation going back to 1290 until I came upon the scene. Okay. All right, until I came upon the scene. So this got the term Inquisition postmortem through the process, what we call library of season, which was the process that carried out through one generation to the next, going all the way back to Ashurton. All right, other Europeans tried to implement that through the library of season process, such as William Penn. Okay, even in the process of using library of season, he did it by way of library of deed, which is something filed within the county record, which is how he acquired possession of the land in lieu of what we call a title, which is not a clear title. It's a cloudy title because there's effects in the title and result of the original owner, which will be the crown. Okay, it will be the crown. Why? Because it's crown land. And we know crown land is identified by the monarch who personifies it. All right. So we see here ecclesiastical fief. All right. The ecclesiastical fief was a deed or what we call a trust that was created based upon the deed poll, i.e., ecclesiastical deed poll, which is the name change or a change or renunciation of your status as a noble, which we see and clearly pointed out in the argument that we are talking about today. So let's look at the term library of season to define the term inquisition post-mortem, okay, before I go into the article. Library of season. Library of season. Library of season is in a card. They're going to use these words in this evidence that we're going to see today. The library of season is a archaic legal conveyance ceremony, library of season, formerly practiced in feudal England and other countries following English common law, used to convey, transfer holdings and property. The term library is closely related to, if not synonymous with, delivery, used in some jurisdictions in contract law or related to law of deeds. The oldest form of common law provides that a valid conveyance of feudal tenure in land requires physical transfer by the transferor to the transferee in the presence of a witness of a piece of ground itself in a literal sense of a hand-to-hand passing of any amount of soil, twig, key to a building on that land or other token, which can be used as a deed poll, i.e. legal document, all right, which you call a title, okay? You call it a title. What are the varieties of library of season? One is called library of deed and library of law. We use the latter. Library of season could refer to either library of deed, whereby parties meet together on the land, transfer symbolically by delivering possession of the land by handing over a twig or turf clump of earth to the recipient, or library of law, whereby the parties went within the site of the land and the transferor with the first, as well as all those that came before him, i.e. Atherton, declared to the recipient that possession was being given, followed by the recipient entering onto the land to remove that cloud of title, i.e. the defects in that title by way of acquiring the title by me coming into the land. Why? How do I know that? By way of the process of inquisition post mortem. Okay? Let's look at it. Inquisition post mortem and library of season. See, I know what I'm talking about. Under the feudal system of all land belong in the under the feudal system, all land belonged to the monarch, i.e. the crown, i.e. the lord paramount, i.e. the corporation sold, and was therefore either held by him directly or by his royal damsnate, i.e. his tenants in chief, i.e. his landlord, on behalf directly or indirectly. Those who held land directly on the king's behalf was known as tenant in chief. When a tenant in chief died without any heir, his land did what? It exceeded to fell into the hands of the king. If there was an heir, the king kept the land until library of season took place. The heir paid the sum of money of relief to take lawfully and assume possession of the land. Very, very, very important. A lot of people who were not the heirs used that process of library of season de facto. Now we have to go back in by way of necessity and justification, do it the right way, which we're going to show you by bringing the claim to quiet the title, because the title that was rightfully ours has exceeded as a result of interstate by way of a process called common recovery, which is turning intel estate into fee simple, which was done by way of alienation, which is subinfeudation, which is a violation of the statutes of statute de conditionalibus, which was also passed by Edward the First to keep the statute, keep the land intel. When we know intel land is crown land, and intel land called crown land is personified by me, the king. All right. So without further ado, let's get into the nitty gritty. All right. I hope y'all remember these terms. Before we do, let's look at Title 8, United States Code 1448. It's right there in the code. So not just if you fill out the Inform 400, but the code tells you if you fill out that Inform 400 that you have renunciation, your allegiance to your national status. All right, you have to announce your allegiance right here. Hereditary titles of orders of nobility. In case the person applying for naturalization has borne any hereditary title or has been of, of any of the orders of nobility in a foreign state, the applicant should, in addition to complying with the requirement of subsection A, i.e., oath of allegiance of that section, make under oath the same public ceremony in which the oath of allegiance is administered and expresses the renunciation of such your title or order of nobility, and such renunciation should be recorded as part of such proceedings. That is what they call your birth registration. Birth registration, civil registration. All right? Very, very, very important. That's called a deed pool, a contract. All right? Because what does it say the deed pool is again? Let's look at it one more time. The first use of a deed poll in England was in 1851. A deed poll is a legal document that can be used for a variety of purposes. You hear that? Once they go that word, purposes. Purposes. All right? So a deed poll can be used for purposes including changing your name, affirming religious views, or renouncing titles or property. You hear that? Renouncing your titles of nobility, and if you do that, then you renounce your right to return to the property, which was intel, a parcel, an estate, an intel estate. Okay, your trust. Okay, very, 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 very important. Let's look at it. Let's go through it. Purposes. What is purposes means? What does it mean? I highlighted it for a reason. For our purposes means in relation to what we are trying to achieve, or as far as our goals are concerned. Essentially, I indicate that something relevant or sufficient only within the specific context of the current situation or discussion. So, what is the purposes for the specific or context of the current situation that we are in as in regards to returning the land back to the heirs? All right, taken from those who took it from the heirs. What is our purpose and what is their purpose and intent? Okay, let's talk about that right now. Everybody give me a thumbs up if you like what you're hearing. We coming to our closing. All right, let's bring the rain, y'all. Let's bring the pain. This is what we're going to use to bury the state of New Jersey and any agency who try to come to the rescue. Because you know the state of New Jersey is an abstract. You know the Crown gives abstract titles out, not concrete. A concrete title will be that which is indefeasible. An abstract title is that which is uh uh defeasible. A concrete is indefeasible. All right. Very, 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 very important. Thank you for the thumbs up, everyone. Chapter one. Remember, business purposes or purpose, the intent. Let's see the intent of the defendants. We're gonna call them defendants. That means the state of New Jersey and New Jersey Land Title Insurance Company, as you can see in the complaint or the brief. All right, and we're gonna use this to show that there is no genuine material fact in dispute that they can raise in regards to why an injunction should not be built on the state of New Jersey in regards to the trespass that they have committed in regards to the land that they have wasted. Okay, they have wasted the land based upon how the land was supposed to be managed. Okay, that's called waste. Section 1 through 6. You can't say you don't know about what we're talking about if you know about Queen Pretoris. They're very well acknowledged on our history, y'all. They're well advanced on our history. The application of it is another thing. Knowing it, yes, yeah, one thing, but the application of it is another. So let's see. Introduction. In order to understand the fundamentals, I'm gonna break this down so you can understand how to read this PDF. Introduction. In order to understand, well said, waste management. Introduction. In order to understand the fundamental of title practice, it is first necessary to comprehend certain basic concepts. The term title refers to ownership of certain estates or interests in land. You hear that? The title refers to ownership. Ownership is synonymous with possession of certain estates or interests in the land, whether the parcel estate, partial estate, or or the land where it's whole. Okay, which would mean it would be allodial, free and clear. Whether it's free and clear or whether it's allodial, in regards to title, okay, the term title, which means ownership, we strictly had to take a good look at the word title in regards to how one acquired title versus having title. Okay? Having title versus how you acquire that title is two different things because title just means possession. It does not mean ownership. All right? It does not mean ownership. The term title refers to the ownership of certain estates or interests of land in regards to us, the English heirs and successors, or contrast to what they're saying, strictly speaking, the means by which ownership of land is acquired or established. So they're only concerned about how they acquired the land, contrast to the land how being owned prior to their acquiring it, i.e., the title. Because we know this is a land title insurance company, and the possession that they got in lieu of their title is defective. It's defective. There's a cloud on the title because you insure defective titles, and if you insure defective titles, which is a cloud of the title, then there's no way you can remove the title, i.e., quiet the title. There's no way you can do it. All right. So they're more strictly speaking concerned with how they acquire ownership of the land in order to transfer the land, all right, or convey the land. When one has acquired title to land, title may be said to be vested in the acquirer, all right, the one who comes into possession of it, all right. Land may be defined as not only the surface of the soil within a particular area, but also so much of the area above and below the surfaces which may be used or enjoyed. So whenever one's acquired the soil, he rules everything from heaven to hell. He is the lawful owner of it. There's a legal maxim for that passed by Edward I, but for the sake of time, I'm not going to go through it. Okay? So it means that land is defined as everything below it, on it, and underneath it. Okay? Above it, on it, and below it. Okay? Thus, the term may include grass, trees, shrubbery, which grows from the soil, or any minerals which exist on or below its surfaces, including water. Structures that's called riparian rights or littoral rights. Structures which have been erected on the land, such as buildings or other improvements, are also embraced within this definition. These are called fixtures. Okay? Fixtures. Now, these are the words of the defendants, not mine. When we speak of ownership of land, we refer to the nature of estates or interests acquired or held therein. Land is also known as real estate, real property, or realty, and distinguished from personal property or personality, distinguished by its mobility. Okay? A fixture is what it is talking about, anything that is attached to the land, etc. All right? Let's move on as I cut to my closer. As above, so below. This is where you get into the capstone, all right, on a dollar bill. The capstone represents the pyra, all right? Pyra, pyramid, the top, okay? Pyra means mid, pyra means top and mid means center, okay? Let's look at it. Further. It said an example, a good example of this building material which is used to construct a house. A brick taken by itself is clearly an item of personality, but once it is incorporated into a house, it becomes a fixture, part of the reality. You hear that? When one speaks of searching the title to a particular piece of property, this is called uh, um, a title search. Okay, it is called a title search. You're right. Titles are not deeds. A deed is just an instrument of possession, of possession. A title is an instrument of ownership. Well said, Countess Walker. So let's deal with the historical background, since we know the process of ownership, how it's acquired it, and how the process of conveying it is done. In order for us to understand that, we have to go into the origin or where it stemmed from, okay? Based upon what the defendants are going to say. Well said, Countess. Point 102, we just read point 101. Let's read point 102 from the defendant's perspective, because our job is to acquire the title. Our job is to acquire the title that has a cloud on it, which is called a defective title. And we know a defective title is a title that has title insurance. Okay, just in case there's a claim put against the title, i.e., lis pendens. All right. Historical background of feudalism. All right, feudalism. It specifically says, remember, we're talking about the term for purpose, their purpose and intent. All right, based upon their understanding of ownership of land, based upon their title, and the conveying of that land based upon the possession of the title. Okay, all right, but the definition of the word title in lieu of it in their possession has nothing to do with ownership. It only has to do with how they acquire ownership, because they don't own it. Why? Because they give out title insurance, and title insurance shows that there's a defective title because you got title insurance, and that means there's a cloud in the title. So that means Jesus has to come and crack the clouds and clear it up once and for all. All right. And we know Jesus is denoted to what? The Son of Man, i.e., the prefix Son of, all right? Which is called a what was it called again? Um Nobiliary particle, all right? Nobiliary particle, such as of or de, like the word de Belmont, okay? Or son of, all right? Those are called nobiliary particles. I ain't gonna have time to break that down for the sake of the class, but let's continue on and close it. Historical background. Because New Jersey was formerly a county of the Crown of England, so that's one admittance that they agreed to. The history and development of our entire legal system, including our system of land ownership, has its root in England. That's two genuine material facts that they justify. But they say for their purpose and intent, not for the crown or not for their heirs or not for the successors, but for their purpose intent, because we understand what it said for their purpose intent for that situation that they're now undertaking. It said for our purpose intent, the development of land ownership began with the successful invasion of England by the Normans in 1066 under the leadership of William the Conqueror. So, in order for them to take control of the land based upon their purpose and intent, was rooted in the development of ownership that was created through the invasion of England by William the Conqueror. I didn't write that, they wrote it. Did everyone see that? If you do, please give me a thumbs up in the chat line. Let's move forward while I wait for those thumbs up. William first introduced feudal system to England. Feudalism is based on the concept that all land is held, whether immediately or mediately, by the sovereign. In other words, all land is owned by the king, and all others having an estate or interest in land ultimately derive their interest from the king. All right. So as we can see, New Jersey, as well as New Jersey land, Title Institute. Definitely know the history in regards to how ownership is acquired in lieu of a title, as well as how it's conveyed in lieu of a title, all in regards to ownership of property. And we know that property, in the eyes of the state of New Jersey, in regards to their purposes and intent, was based upon the undertaking that was established by feudal law, which is nothing more than fee simple, which is how ownership is owned today. That was established under feudal land tenure, that was established by William the Conqueror, going back to 1066. And this is their purpose and intent. That's the intent that it's established for this present day. I ain't just making it up. Let's read it for ourselves. Brother Newby, you're not a British loyalist. You're an English loyalist. If you're a British loyalist, that means that you'll be of Scottish descent. If you are of Scottish descent, that means that you'll be a Scottish national. If you are a Scottish national, that means that you have to now pledge your allegiance back to the English crown, because the Scottish crown and English crown have separate body of politics. All right? So you don't have to continue to say that I'm a British loyalist. You're an English loyalist. All right? Because the English loyalist was rebelling against the British crown. Okay? They wanted the rights of the Englishman, which you are clearly are if you're here on this channel, brother. All right, so let's correct that speech. Let's move forward. William I introduced feudal system to England. Feudalism is based upon the concept that all land is held by the king. So if that is the business purposes for the state of New Jersey, as well as New Jersey Land Title Institute, based upon how they came to acquire land, and the land that they acquired is the land that has defective ownership in it based upon the origin of the title going back to the original owner. All right, we must understand that. They're going to tell you. I'm not making it up. They're going to tell you. Let's move forward in lieu of the closing. By way of illustration, let us assume that the entire nation of England was one huge tract of land. This is talking about one land without land tenures, which means that the land can be considered allodial. And the only land they talking about in regards to this article is right over here in North America. Okay? They talking about right here. So they're saying, assuming this land over here in North America was one big landmass, okay, on one big tract of land, all right, called England, all right? Because if it was called England, then there wasn't no chain of title that had a cloud on it, because the only way a quiet title in lieu of a defective title will be in the king, because all land is allodial, and that will mean there is no encumbrances on it, all right? So it says that just for saying, for a figure of speech, just say the huge tract of land was one landmass called allodial land under the authority and under the Lord Paramount called the king. Then the king decided, you know what, I'm just going to convey this land to either heirs or foreigners. That's the question we have to ask ourselves. Who were the ones based upon the transfer to the transferee? Was it based upon intel or was it based upon fee simple? Because if it's fee simple, then that's subinfeudation, which is alienating of land to people other than the heirs. Okay? We must comprehend and not use these words and terms loosely. All right? So we just read it for ourselves. The chief nobleman in turn conveyed small portions to less noblemen, who in turn reconveyed still smaller tracts to others, and so on and so on and so on and so on. These conveyances created a pyramid-like structure with the king at the top. So that means if the king at the top, there will be no gap in the pyramid, okay? Because the king in the pyramid is one solid foundation, one body of politics. There is no separation of church and state, okay? Because the church will be the king, because the king represents God, and God's son is the Lord God. You look at Jefferson, that's what it said, the Son of God on earth, if you read it from left to right instead of right to left. So let's move forward. By way of illustration, let us assume that the entire nation of England was one huge tract of land. The king decided to convey the land called entail estates to heirs, okay? Heirs, not foreigners. Very, 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 very important, because this is how we're going to determine the evidence that's before us, all right? We understand common soakage was created for serfs, villains, all right? Commoners, all right? Very, very, very important to understand that, because when we're dealing with uh, uh, when immigration immigration started with Europeans. And we said what was that we were talking about earlier today? What was the indentureness? We said the indentured servants were those Europeans who immigrated over here. All right, who immigrated here. So it said, however, it will be inaccurate to suppose that these conveyances enable the transferees to own land conveyed. Once again, I repeat, however, it will be inaccurate to suppose that these conveyances enable the transferees to own land conveyed. Under this system, one merely possessed or held land subject to superior rights of the transferor, i.e., the one who was able to transfer it, whose possession was immediately above the transferee in the feudal pyramid. The foregoing suggests that feudal estates can probably best be characterized as a series of leasehold or sub-leasehold, which pretty much what you have today. On the other hand, these estates, so they're giving you the alternative. This is how they do it now, which is through substitution, which is alienating through common recovery, which is what we call fee simple, which was against the law. And it says, in the word transfer under certain circumstances, they are therefore sometimes referred to by terms of base fees. Did I miss something? 1 second. What was that? All right, let me go back up one. It says, on the other hand, these estates descended to the heirs of the possessors thereof and were transferable under certain circumstances. They are therefore sometimes referred to by the term base fees. The estates acquired under feudalism were known as tenements, the party in possession as a tenant, and the man in possession as tenure. Hence the word land tenure. So we see that based upon subfeudation, based upon the common recovery practice that was created through converting the land from entail to fee simple, based upon subfeudation, which is a violation of law, this is how they were able to steal the land from the heirs. How I know it? Let's go a little further. Right here. This is page 3, if I'm not mistaken. This is page 3. Now, we filed on the news carrier in 2005, January 14, 2001, January the 14th, my birthday, and this edition of this article we're reading was actually published in 2021. The same year we established the state of emergency or a state of necessity based upon the justification of the estate being extradited to the state of New Jersey, as well as the defendants in this matter by way of placing the cloud on the title, which is the effective title. We had to now justify our actions by necessity, which means to break their law. To break their law, because the law they used to steal it was through library of deed, which is filed to the county clerk. We didn't have to use that process. We used the library of law, which is to go into possession of the property and then create a deed in lieu of that conveyance and then file it for the public record. Okay? Based upon the chain of title pursuant to our filing under New Jersey Revised Statute, Title 46, Clause 3-6, which says the land is allodial. And if there's allodial, that means that the only person, i.e., can get the land is Lord Paramount, i.e., the Crown, which the statute, Title 46, Clause 3-2, speaks to. All right? Let's move forward in closing. Each tenant thus held his tenement in consideration of the services due to his superior. The nature of these services defined one tenancy, owing a part to the personal nature of these obligations and part to the mystical nature of season. Season means possession. The process by which tenant took possession of tenement, i.e., that is the fief. Feudalism was not merely a scheme of land ownership, it was also a moral, ethical, and social system which defined the relationship among different classes in medieval English society. So, I mean, it was based upon your status, okay? Your status. As noted above by the defendants, i.e., the state of New Jersey and New Jersey Land Title Institute, which placed the cloud on our title, which made it defective. They stated right here, during the reign of Edward I, the practice of transferring estates through a device known as subfeudation became widespread. So they understand at the time that Edward I passed Quinta Praetoris, it was a result of alienating of land that actually belongs to heirs. What heirs? The heirs that descended from the Plantagenet kingdom. All right, the Plantagenet dynasty, which was a conversion of the House of York and the House of Lancaster that resulted in the War of the Roses. That's still going on today. This is how they're still in your state, which was created by who? Henry VII. And Henry VII founded the House of Tudors, and this is how they started what we call prescription of sovereignty through by what we call conqueror, okay, or conquest, which they changed the word to what we call the damn word discovery. All right, nothing strange. Let's move forward in closing. Statute Quinta Praetoris. Now we read section 1.01, 1.02. Now we read them section 1.03. 1.1 talks about introduction. 1.02 talked about what was it? Subfeudation, if I'm not mistaken. Background on feudalism. All right, yeah. And then 1.03 deals with Quinta Praetoris, the law passed by Edward I, where you can find right here in 2023, 2024, as well as it's going to be there in 2025, and it's quoted by the same term, Quia Imperatoris Terminum, right? For itself. Now, what's funny about this is that in the section 1.03 that we're reading in New Jersey Land Title Institute in regards to the clouded title, i.e., defective title, which needs to be quiet, by way of reassuring that the law that was initiated by Quinta Praetoris was actually initiated by New Jersey Land Title Insurance, and they mentioned it by name, which is actually mentioned in New Jersey by statute 46:3-5 and 46:3-15. And when you read those statutes, it clearly shows you in those statutes that that's how they converted from the original intent of the legislative intent and created it to fit their modern terminology in regards to how they acquired land ownership and land conveyance, all right, which they're going to tell you as we read through the rest of this article, all right? Thank you, Brother Cornelius. Nobody can spit like me, brother. Thank you. Appreciate that. So the statute Quinta Praetoris. Since these incidents were of great economic value to the overlord, they naturally turned to the king for assistance. His response was the enactment of the Statute Quinta Praetoris Terrarum. So if this had no effect in New Jersey's modern-day statutes in 2021 and its 5th edition, why are they talking about Quinta Praetoris passed by a so-called king that was supposed to be over there in what they call United Kingdom? They make a reference to him over here, and it's found over here in statutes in New Jersey legislative intent in regards to how they stole the land based upon their purpose and intent, which we're going to continue to read further on in this lesson, this PDF. Let's see. So it says, Statute Quinta Praetoris, since the incidents were of great economic value to the overlord, they naturally turned to the king for assistance. At the time when they created this pamphlet, was no king there, because no one understood Quinta Praetoris like I understand it. So as a result of me understanding it like it's supposed to be, this sealed their doom. How I know it, let's continue on with the reading. That says, although it is unclear from the literal reading. See, they say it's unclear about the literal meaning of the Statute Quinta Praetoris in regard to purchasing of land. It didn't say nothing about buying of land, because the Statute Quinta Praetoris was a law passed that said His Majesty law on the buying and purchasing of land. They left the whole part of the script out. Why did they do that? Let's see why. That says, although it is unclear, and that's not by chance from the literal reading that they're doing, the statute was interpreted to prohibit further subjugation. So they agree that alienating should not be done. But yet, for their purposes, let's read it in entirety, but most specifically for our purposes, you hear that? It also gave the tenant in fee simple, not the heir entail, who should be the tenant, but the tenant in fee simple through common recovery, which is alienating through subfeudation, which Quinta Praetoris clearly forbids the right to substitute another in place without obtaining permission from who? The overlord. That was a violation of free and common soakage. a violation of freedom common sockets. It was a violation of Quinta Pretorius that was supposed to be passed from generation to generation based upon Inquisition post-mortem. Okay? It says that, but most significantly for our purposes, i.e., the defendants, it gave the defendants, i.e., the one who created the feasible process through common recovery, which according to 46.3-10 under the revised statute, it says it is abolished. Okay, but yet they still give us evidence to use against them in regards to their still practicing the process, because once again, it just said, but most significantly for our purposes in the tent, it also gave the tenants and fee simple the right to substitute another in place without obtaining the permission of the overlord, i.e. the tenant the chief, not Lord Paramount, not the crown, not the king, not the corporation soul, but the tenant in chief. And once the tenant in chief died, he substituted to other people who were not tenants in chief, who are not heirs, but just anybody coming over here and taking possession of land through the de facto process that they set up through fee simple. How I know it, let's read on. This was, of course, a radical concept, which was completely at odds with the pyramid-like structure of feudalism. All right, so they totally created their own structure. That's why the capstone is missing. Thus, we created the modern fee simple estates and land because the tenant in fee simple was now the owner in fee simple. His relationship with the transferor, i.e., the one who transferred the land, and now the tenant in chief and possessor of the land through fee simple was now considered to be what? Allotio. The opposite of whether it was under land tenure rights or feudal tenure rights. They totally changed the whole game. Can everyone see what I'm saying? Please, if you do, give me a thumbs up in the chat line while I come to my closing. Oh, bingo. Of course, the king still remained as the source of the title to all land. Nevertheless, the prohibition on subdivision coupled with the right of substitution eventually caused the system to be vastly simplified. Because the transfer of land was no longer involved in the pyramid-like structure, the transferee took his place. Did you hear that? I didn't write this, they wrote that. So let's come on to our conclusion. Let's come to our conclusion. Decline. Let's see. Data development. So this is where it has come to in closing. Right here. This is page 7. All right. The forms of deeds and mortgages and other documents which were developed in the 17th, 18th centuries to create a transfer of a state and interest in realty, not equitable interest, but legal interest in realty, i.e. property, were remarkably similar to those in New Jersey until quite recently when plain language forms were developed. So they're saying New Jersey, as well as the process of conveying and transfer property based upon how they acquired the property, contrast or notwithstanding to ownership of that property prior to their acquiring it. The term in lieu of the instruments used in denoting to possession, such as deeds, mortgages, or what they call deeds of trust, and other documents such as the nature which were developed in the 17th, 18th century to create the transfer of estate and interest in realty were remarkably similar to those in New Jersey until quite recently, when the plain language forms were developed. Here we go, y'all. The term indenture, with which many instruments traditionally begin, refer to the ancient practice of writing 2 or more copies of a document on one large sheet of parchment. Okay? This is called the dead pool, y'all. This is called the dead pool. On one large sheet of parchment. They were then cut apart with a wavy line and a denture, and a copy was given to each party to the instrument. All right. Subsequently, the parties could compare their copies by placing them together. If the lines matched the documents were the same, and contrast, only one copy was made a depot which had smooth edges. Okay, that's That's called the deed of the name change. Okay. Deed to change name by way of you taking an oath to become a citizen by way of the naturalization process through Form 440. All right, which in lieu of that proclamation or ceremonial endeavor, it denotes to a renunciation, which is the deed poll, which also denotes to renunciation of titles of nobility and property, which is how they stole their property, because they're telling you right here. By creating a deed poll, they made you a deed, which is not a contract, but a legal document to note to a single person based upon the registry with the vital statistics, which has now created a paper trail. A paper trail. And then they say that when anytime you go before the court in regards to declaring who you are based upon that paper trail, they got the deed right in front of them. Okay? They got the deed right in front of them. All right? Deed pool. And let's define deed pool again before we close out. Based upon the varieties of what deed pool means. Deed pool. A deed pool is a legal document. Hear that? A legal instrument that can be used for a variety of purposes, including changing their name, affirming religious view, or renouncing titles of property. The term deed pool comes from the word deed or poll. So when they created a deed pool by you registering with the government, they renounce your title of ability by making your name from a legal name, i.e., your true name, to that of a trade name, i.e., a commercial name, which establishes a contractual agreement under the deed pool by way of the piece of receipt that you get. All right? Very important. But none of those receipts that you got determines that the deed pool is valid because you have not proven that you have now renounced your citizenship because you don't have that form in Form 400 form. Okay? So you still got a chance. All right? So in closing, let's go back to deed pool. Deed pool. Deadpool, Deedpool can be synonymous because they all in it together. So deed pool, also known as a deed of change of name. When you got these names, you didn't register with no government. It was already part of the government because there was already government here, and the government was the government of your nation, which determined your nationality, where your surname is sent down from, which is your title of ability or title of status. Okay, so it says in closing, the most common use in a name change through a deed of change of name, often referred to simply as a deed poll. You hear that? A deed poll. All right, so they clearly understand what it is that they're doing because let's go to deed change of name in closing. Deed of change of name. All right. A deed of change of name is a legal document used in the United Kingdom, Ireland, and we know United Kingdom and Ireland is Scotland, okay? Because that was the unification of 1707. So they gave you the status of chattel property because Great Britain incorporated slavery in New Jersey, which is a status of indenturedness based upon the piece of paper that you got as a receipt of the indentured contractual agreement, which was created by the deed pool when they signed you up as a worker, i.e., a resident. Whether you're temporary, whether you're permanent, whether you're naturalized, whether you're born, you are not a citizen because if you were, you would have that inform 400. And if you ain't got, then you pretty much out of luck. Okay? You pretty much out of luck. Okay? So it says a deed change of name is a legal document used in the United Kingdom, Ireland, and some other countries with a legal system based on English common law. So why are United Kingdom and Ireland using English common law? And they ain't English. To record intended changes of name by a person or family, it is one use of a deed pool. Okay? One use of a deed pool. And based upon the ecclesiastical nature of a deed pool, it clearly says that you have given them consent. Ecclesiastical deed pool is a valid form of deed pool, therefore, deed contract whereby a true person, legal person, first expresses, affirms, and conveys certain right to another party who is then lawfully bound upon proof of receiving in accordance with the canon defined under Article 133, which is nothing more than having a seal, which is the consideration to validate that you are now indentured. Okay? Indenture, which also has to do with slavery, but we know the first indentured servitude that was over here was based upon immigration. If you're not an immigrant, then that status does not fit you or not be fitting to you. Okay? Does not be fitting to you. All right. So with that in mind, make sure I covered everything. Once again, this is our complaint. All right. Undisputed, genuine material facts that we just discussed today that will be presented before the Chancery Court this coming Monday. All right. I'm asking each and every one of you who are watching this class today, donate $10. Okay. I have to use my own money to pay this fee, as well as assistance from Brother Milligan to help pay the fee, which is $250. So I'm asking each and every one of you, send me $10, $15, $20 to help pay for this fee so you can have or you can contribute to the progress of what it is that we're trying to do on behalf of returning the land and removing the cloud of title, inquiring the title for your benefits. All right? For your benefit. So with that, let's see. You can send a donation to $ Clifford Jefferson L, or you can send it to the Third Temple English Church of England. All right? And it will definitely get to me. All right? And I definitely reserve a place for you in what we call our heaven. All right. So with that, I'm gonna open the floor for questions if there are any questions. All right. I'm gonna open the floor for questions if there are any questions. Please shoot now. Please go now. Forever hold your peace. As well as all those who watching, please leave a comment in the not in the chat line, but leave a comment in the comment box once this video is posted. All right. I don't want no pictures, no emojis, no thumbs up. I want you to show me something that you comprehended what's being said today. Thank you, Brother Cornier. When you donate, please let me know who sent the donation, either to my Clifford Clifford Jefferson L, or the Third English Church of England, so I know who's supporting. All right. Once again, $10, $20, $5. Once again, C.A. Murphy, thank you for your contribution as well as for your continuous donation, Brother Milliken, as well as Brother Countess Countess Milliken. All right. Brother Milliken. Oh, they might be related. Countess Milliken, Countess Middleton, parts of Countess Middleton and Brother Milliken. Thank you for your continued support. All right, I'm waiting for some questions. No questions, brothers and sisters. Come on now. I know I got some questions out there. Let's go. So I mean, no question. That means everybody pretty much understand what's being said today. All right. Thank you, Brother McGarry. I appreciate your love, brother. Appreciate your love. Everyone. Appreciate your donations. Sing your love. What I'm really asking for each and every one of you that has some type of uh, uh, connection to other people that have platforms that would love to hear this information, please reach out to them. All right. You know, I'm not biased. I'm here for everyone who want to return home. So please, those who got platforms or pages, uh, uh, any network that you can go to get this information, it is a must. All right. So with that, I see there's no questions brought before me. So as always, I'm going to greet you as I meet you, and that's the peace and love that our ancestors has preserved for us in this day and time. And with that, I'm gonna say peace. I'm glad you enjoyed it. All right, Archbishop, when you get time, you give me a call. One love.